All right, let's go ahead and get started. Everyone, thank you for joining us tonight. My name is Michelle Isherwood. I'm the secretary of the Phi Alpha Delta Foundation Board of Trustees. Tonight we have a great guest, and I'm so happy that he is here to share with us. So I want you all to welcome Judge Samuel Thumma. He's a judge on the Arizona Court of Appeals. And again, I'm going to give him a chance to introduce himself and then go into the topic. If you have questions, please put them in the Q&A and we will get to them sometimes during or between or at the end of the slides. Again, welcome, Judge Thumma, and please introduce yourself and go ahead and let me know when you want me to advance.
I sure will, Michelle, and thank you so much. What a treat it is to be with you all today. And it is, I was just telling Michelle before we started, I'm looking at kind of an Ed Mel sunset over my left shoulder behind the screen that I'm looking at here in Phoenix, where it's just a whisper after 6 o'clock. I will tell just a little bit about myself before we get started, but Michelle is absolutely right on questions as we go along. I have a tiny number of sort of slides that I've pulled together with 10 sacred cows and 10 pet peeves that apply really across the board on legal writing. But it is far, far, far more important to me that if you have a question, you raise it and we get a chance to have a meaningful conversation about that. So with that preface, I grew up outside of a tiny little town in Northwest Iowa wanting to be a veterinarian and went to undergraduate at Iowa State, ran into zoology and organic chemistry. We didn't get along. And so I then kind of floundered, but had an opportunity to get a couple years worth of graduate tuition and was fortunate enough to get into University of Iowa's College of Law, where I graduated in 1988. I was on law review back and went to school back in the day when writing classes were not graded, right? They were a box that you had to check. And because I was on law review, the boxes that I needed to have checked to get my diploma were taken care of without actually taking any specific writing classes. I clerked then for a federal judge named David Hansen, who was on the Northern District of Iowa's U.S. District Court. At that time, later on, went to the Eighth Circuit Court of Appeals, was chief judge of that court for a time, and is now resident in Iowa Falls, Iowa, as a senior judge. I really became a student of his writing style because I worked for him for 2 years. And it was awfully important that I learned his writing style. He had still does, has a good, clean, right to the point kind of approach to legal writing. I then worked at Arnold Porter, then called Arnold Porter, in Washington, D.C. for a couple of years, did commercial litigation defense work there, and worked with what I thought were some very good writers, and began to start to edit other people's writing from time to time, just a little bit. And that's where I would submit, and we'll talk about it some more, you really become not only a student of writing, but become better and can really enhance and improve when you start to edit what somebody else writes. I then came to Arizona, married my wife now of 30 years. She also is a lawyer in town, worked for the Chief Justice of the state Supreme Court, which is a wonderful sort of transition into the law here, and wrote a lot in that process as well through a different voice for a different sort of client, if you will, judicial officer. Then was at first Brown and Bain and then Perkins Coie Brown and Bain for about 15 years doing commercial litigation defense work in Phoenix, and worked with some just extraordinary writers that caused you to be very, very humble, because I was not anywhere near as good as they are. Then was a trial judge for 5 years, on juvenile court for 3 years, which is one of our major rotations here in Maricopa County, and then in criminal for 2 years, presided over almost 40 felony criminal trials in those 2 years. We were kind of trial machines, just given the way things were structured, and then have been on the Court of Appeals for almost 11 years now, where I really have become a student of good writing and trying to improve chronically what I do with my writing approach. Writing's one of those things that seldom I have heard people described as being too smart. I have never heard somebody being described as writing too well. And so it is something that I have become a student of, not because I'm good at it, but because I'm not particularly good at it. And I've tried to identify ways to be able to work through my deficiencies. And some of those are identifying sacred cows and pet peeves that we will talk about as we go along. So let's go to that next slide, Michelle. What is then good writing? And there's no single answer, right? I took a class right when I was appointed to the Court of Appeals on writing at the National Judicial College in Reno, Nevada. For judicial officers, state judicial officers in particular, they run some really good courses to try to help you enhance different aspects of what you do all day, every day. When I first became a trial judge, I took a week-long class there on evidence, which seemed important as a trial judge. And I thought as I was starting on the appellate bench, I ought to really take even more seriously this writing thing. And there are two very different instructors, and I don't remember which one had this quote that I'll read in just a second, but Karen Hunt, who was a retired trial judge in Anchorage, Alaska, and Elizabeth Francis, a professor at University of Nevada, Reno, who is still teaching this class, by the way. I've co-taught it with her some since, but had this idea, and this is attributed to Ira Glass, right, on National Public Radio. This thing happened, and then this thing, and then this thing, and this is what it means. And I hadn't ever thought of writing in that context, but that's an awfully good way to kind of describe what good writing, one aspect of what good writing might be, sort of a North Star, a target that we might all have when we try to sit down and put used to be pen to paper, now fingers to keyboard on how to write. One thing with that too, just given how we write, it's a lot easier to put a whole bunch of words on a page now using word processing. That wasn't true when you, and undoubtedly there may be some people who still do put pen to paper, and that sort of added pain in composing can affect how you write. Just the medium that you use to write legal or other text can really alter how the quality of what you do. And how we read is quite different now. There are a bunch of studies. Most of us read on screens. Our court has been paperless since I started here about 11 years ago. And the upper left-hand corner is really the focus of what you do when you read electronically. It also, and I'll start with one kind of Sam's pet peeve, it also affects the use of things like footnotes. There's some very, very bright legal writing scholars who will tell you you should put all your cites in a footnote. Let me encourage you not to do that, particularly if you're reading on a screen and you do that. I don't know if the source that you have cited is a binding U.S. Supreme Court or Supreme Court decision of our state, Arizona, that I am duty bound, literally took an oath to follow, or if it's a law review piece that I may not be particularly intrigued by at all, or if it is a dissent in a Wisconsin Court of Appeals decision that I'm certainly not bound by. If you keep text, the citations in your text, it will help me down that path. And it also will help you in your writing to reduce clutter. We'll talk about that in just a second. But let's go to that next slide, Michelle. So what is good writing, right? There will be and soon are bots that will be able to define that. There's software programs. I use a software program called Briefcatch that I like quite a bit that helps me some, but there's no sort of mathematical sort of precise way to figure out exactly what good writing is. It's through the eyes of the reader. And that's a human understanding. Anyone who's given a book as a gift will know that sometimes your favorite book will not be well received by a very, very good friend of yours, and that's okay. That's okay. But good writing really is many things to many people in many contexts. Again, what you may like, but your friends may not. I'm probably a good example is next bullet point, text that critics may like, but that I may not. Blogs, posts, newspapers, all sorts of writing that may appeal to the masses and not you, or the other way around. So it really is kind of in the eye of the beholder. But like that Ira Glass quote at the core, good writing tells a story. Let's go to the next slide, if you would, Michelle. But it also does just a whole bunch of other things, again, depending on context. Legal writing is exactly one of those contexts. If you read, if your practice or studies include medical work, you'll note that medical writing is quite different than legal writing. Writing in other disciplines is quite different as well, where you may have a bibliography with just sort of general cites, whereas the law is really pretty specific. You want not only a page number for that quote, but sometimes a paragraph number, very, very specific citations that the law demands. We have technical requirements. We use terms of art. We definitely, and I would say it's more even than dialects. It's almost different languages that we speak. When you try to explain to a non-lawyer what you're working on at times, things can become so jargon-based or code-based that it's almost like interpreting or translating one language to another. We do have to deal with jurisdictional things and timeliness and a whole bunch of other things that fiction writers aren't encumbered with. Legal writing, I've found, really is hard because you both want to tell that story, but also you have to comply with a great many requirements, almost all of which are based on local law. So you can give some kind of general thoughts that you need to account for, but you can't provide hard and fast rules for exactly what's required in a given direction. So the question, if you don't mind, Michelle, me addressing that, is it redundant to place those sources for your case law both in the body and in the footer for easy reference based on what you explained? I would say yes, it is. I need the material once. I don't need it twice. And the reason why I suggest to keep it in text above and beyond avoiding sort of mischief on misunderstanding when you're reading on the screen and not necessarily having immediate access to footnotes is footnotes, and we'll talk about this, sometimes become sort of the cemetery for things that you spent a lot of time on, but you don't want to eliminate in your writing. And that's a bad reason to include text. If you keep it in the text, your citations in the text, by definition, it will require you to be selective about what you keep in there. And we'll talk about that in a second as well. So no, I don't need it two places, but I would encourage you to think about putting your citations in the text right behind the sentence or the principles that they support. Let's go to the next slide if we could. Great question though, and please, please, please keep them coming. So what's the opposite then of good writing? And I'm starting with this kind of extreme, qualitative assessment for a reason that to definitely make the point, I do not have a corner on good writing or not, hopefully not so good writing, right? I do think I can tell a story, but I am not a gifted writer. I've become a student of the craft because of my weakness, not my strength. And the same with evidence. I've become a student of that craft, not because I knew it, but because I didn't know it, and I needed to work hard to continue to try to improve. I do study and really enjoy good writing of all types, particularly good biographies, good poetry, although I can never figure out how to read poetry aloud, like some folks just have a gift for. But the other thing, I was chief judge in my court for a time, which meant my legal legal casework dwindled. We didn't have nearly as many cases when you're administrative judge, and I realized I so missed that that when I ended my term as chief about 3 years ago, I really turned back to try to redouble my efforts to improve my writing. Whether I've succeeded or not, I don't know. You would have to look at what I wrote both before and after as chief. I can tell you this: the voice that I use with certain kinds of writing, in my opinions, has changed quite a bit since I started here. I could identify, if you stripped names out and gave me text that I wrote 10 years ago and that I write now, I'm pretty sure I could tell you when they were written, even if I didn't know the facts, just given the approach that I've either grown to or shrunk to, one of the two, whichever your perspective is. But okay, so let's with that preface, let's go to two perspectives through my eyes about types of writing. Sacred cows, right? And by that I mean things we see a lot but may not think a lot about. And then pet peeves. And those are things that cause, I would say us, but how about me, right? So to stumble, things that kind of catch in my mental throat when I read, and I kind of wonder why they're there. There is no question that you may not view these sacred cows or pet peeves that we're going to talk about as sacred cows or pet peeves. You may love them, and that's great. I am more than happy to have you view things differently than I do. This is not a, think like Sam sort of conversation, please. And my hope actually is that you'll learn from mistakes that I have made as we go along here. But the goal is really to have you think anew, maybe, or again, about different approaches to writing and what I have categorized as sacred cows and pet peeves. So with that, let's go, and there'll be 2 slides with 5 listed each. And if I was better at PowerPoint and getting it to Michelle, they'd populate just one bullet point at a time. But let's go through these. So, all right, pardon me. The first one is the lower court, right? You see courts using that phrase. You see briefs using that phrase, and at times it's technically true. But what I think it doesn't maybe show is quite the amount of respect to a court that decided something that's being appealed that you might want to think about going forward. I never used local court in my judicial or lower court in my judicial writing because it could be perceived, I think, as derogatory to folks that are also judges. Now, that doesn't mean I agree with what they do. I do kind of grade other judges' papers in terms of appeals, and I reverse some judges and they get sad. And that's kind of how things work with appeals. But how about the trial court or the family court or the criminal court or the court? If it's really clear which court it is, that's even better because it's shorter and you don't have to add the qualitative assessment. But lower court at times can be viewed as a bit dismissive. I will tell you one instance that I had where I sat with we sit in panels of 3. One of the judges that I served with had been what is called a court commissioner. in our state, the equivalent kind of a magistrate judge in the federal system. That's a bad analogy, but bear with me. And it's the court commissioners are not appointed by the governor, like all the other judges are. They're selected by the presiding judge of a given court. And this attorney just could not get beyond the fact he would lead with over and over and over again that it was a commissioner who decided the issue. It was merely a commissioner who issued the ruling. So how could a commissioner should be owed no deference in their decision? And I could kind of feel my co-panel member sort of bouncing up and down because she had been a commissioner for quite a while and she's a terrific judge. So ultimately I got to the point in oral argument encouraging counsel to focus more on the decision and less on who made the decision going forward. But that was an opportunity for that lawyer to learn how to better read the room. How about that? So that's sacred cow number one. Sacred cow two, personal pronouns. I see this quite a bit. Particularly he and she. Now, he and she is great if there is one man and one woman in the case, but almost never is that the case. Family court cases without children, that can happen. But next time you use a he or a she, see if there's an opportunity for confusion in the way that you use it. There are other ways that I see that a lot, and I undoubtedly do that a lot. But I have many times been looking through drafts or even final decisions where the reference to he is not at all clear. And you need to go back and sort of revisit what the intention was and to find out which sort of he we are referring to in that course. Question, and if you're okay, Michelle, with me sort of fielding that, should we also avoid using the term the court below? I would encourage you to avoid that if there is a way to avoid that, right? It might be the trial court. It might be if you're seeking, review by an apex court, a Supreme Court, the Court of Appeals. There's probably a better way to refer to it than lower or upper. Now, one footnote with that, and remember I said not to use footnotes, but or to limit footnotes, is we literally have what are called limited jurisdiction courts in our state. Municipal courts, justices of the peace, and they are referred to in a rule set as lower court. The lower court with an appellate rule set. And I kind of pushed back and said, well, wait a minute, why don't we rephrase this when we're amending the rules so it talks about limited jurisdiction court or city court or justice court. And actually the justice court, justice of the peace had become so that term had been so normalized, they wanted to keep lower court and limited jurisdiction court because it had become, attuned in their psyche. So either I was too late or I was just wrong in pushing back on use of that term. But yeah, if you can't avoid it, I'd encourage you to do that. On occasion, you might please some people if they're kind of imperial judges, right? That want to be a upper court. But you'll run into people on so-called upper courts, appellate courts, who have been trial judges. I'm one of those. And I will not ever be offended if you refer to the Superior Court. And I might get a little bit twingy if you use lower court. So just something to think about in your legal writing. Defining terms, I have seen more than my share of introductory paragraphs that will have any number, sometimes 8 or 10 or 12 parentheses with open quotes, hereinafter X, hereinafter Y, hereinafter Z. And unless, first of all, I think there are better ways of doing that. If it's husband and wife, maybe you could use husband and wife. But until you get me into the story, the odds of me remembering what these defined terms the odds of me understanding what these defined terms are as we begin are really, really, really small. And then almost inevitably, if you do have a ton of defined terms at the start, there's at least one that you won't get to next until about page 4 or 5 or 6. And then almost without exception, I've got to break my reading of your good writing to go back to that first paragraph to say, okay, who is this again? And how do they fit into doing this case that you're presenting? And you don't want that. You want me to understand, and you want everybody to understand pretty seamlessly what you're referencing in a sort of real-time kind of way. Acronyms, we live in a world of acronyms, don't we? And I'm sure I am guilty of that. The Indian Child Welfare Act, ICWA, right? Uniform UCCJEA and family court disputes. There's some, and that's, you get a environmental case. Boy, you live in a sea of acronyms. And if you have to use them, I get it. I'm not saying never, but be really cautious about whether you are using them and when you use them, and then don't use acronyms that are almost the same but not quite. And then usage becomes wildly important to make sure you're not confounding or confusing the acronyms that you do use. Legalese, and every lawyer has cringed at their in-laws jokes about writing a will or party of the first part, or any number of sort of bad or old movies. Just be aware of that. I think when you read really good prose, you're probably not craving more legalese when you do it. And so just see if there's a way to kind of avoid that. Sometimes there isn't. Sometimes there are terms of art that you just absolutely have to include, even when they're painful. But think hard about whether you can avoid those. All right, so those are Sam's 5 first sacred cows. Michelle, if you go to that next slide, and we'll talk about my second 5 sacred cows. Yeah.
Before we advance, there was one question about pronouns.
Sure.
And the questioner asked, how can we be sure that you are using the correct personal pronoun? Should we not be careful about assuming what pronouns litigants want or use?
Let me answer the second question, and those are really good questions. The second question is absolutely we should be careful about assuming what pronouns litigants used. Now, the first one is, how can you be sure they're using the correct personal pronouns? One way might be to not use them, to use a last name, or in a case, a family dispute where everybody has the same last name, maybe use first names. That implies a degree of, knowledge or familiarity with the person that may not be always the best thing. When I write about parties using first names, I may not have ever met them, but I use that sometimes to try to allow for clarity. And if you can do that, you actually avoid the question, you avoid the usage term with respect to personal pronouns. So different focus for maybe not using personal pronouns, but a really good question, and something definitely to be careful of and to be mindful of when you in your legal writing. So let me tell you what I would see from time to time, and this may be an issue unique to the appellate world, but I think there's some examples like this in trial court proceedings and other kinds of legal writing as well. And I come at this from a litigation perspective, recognizing there's an enormous amount of legal writing that is not litigation based. But what I would see, and there are 3 basic standards of review that might fall into this bucket. Legal issues are reviewed de novo. Factual issues are reviewed for an abuse of discretion. Combined legal and factual issues are reviewed, as if they were, legal issues. So they're reviewed de novo. That's fine. And I need to know those standards of review. but I need to know which one applies to a specific issue. So if you have a 3-issue appeal, one of which is an abuse of discretion standard and the other 2 are de novo, you need to tell me that with respect to each of those issues, because the lens with which I look at those issues is quite different. De novo, I owe deference to no one. I am asked to look at an issue anew, almost always legal issues in that context, whereas a finding of fact, for example, or a credibility determination or weighing and assessing conflicting evidence is abuse of discretion standard. So tell me, don't just tell me the generic standards, tell me which standard applies to which specific issue. That is a helpful tool. Telling me what I just sort of dictated to you is not helpful because it doesn't tie which issue, would require me to apply which standard. Next, sacred cow that I will toss out here is long, complex sentences. Sometimes they cannot be avoided. Oftentimes they can be, and a really good writer will know how to both chop long, complex sentences into pieces and also how to vary sentence length. I worked for a fair time with a genuinely gifted legal writer, who I learned a boatload from. She since is retired, but she was a gifted writer. And she used a phrase from time to time as a sentence, not so. Just that sentence, just not so. And I thought, oh my gosh, how wonderful is that? To the point where I had a clerk who would try to sneak that sentence in like every draft that she drafted for me. It on occasion made it through the editing process, but really work hard to avoid long, complex, kind of stereotypically legalese sentences. Now, Michelle, I see another question, I think in the question answer. Do you have an opinion on using they as a singular pronoun? Attorneys seem to be split on this, but I can make writing simpler to see each party filed their brief late. And again, it's got to be, I thought the question actually might be a little different on the pronoun front, but if it's clear who they is, I don't have a quarrel with that at all. And you're right, it can be an expedient. You can take 2 longer, kind of clumsier sentences and put them into one that's has even more meaning and takes a lot less time to get through. So I have no quarrel with that at all. And some of this too is based on the fact that I spend much of my day reading, and I oftentimes I like that when the briefs are good. When they're not, I like that somewhat less so. So just understand that. And if you can say something, we use word counts. If you can say something in, I don't know, 5,000 words instead of 7,000 words, you're probably ahead. You're punchier. You're getting right to the point. There's not the throat clearing that sometimes and other sort of crutches that legal issues and legal writing sometimes involve. We talked on point 8 just a little bit, our sacred cow 8, footnotes that are dumping grounds for marginally relevant information. And I'm positive I've been guilty of this in my legal writing, that issue that's sort of tangentially relevant, and you spent an enormous amount of time researching it, and you got some good stuff, but it still is a tangentially relevant sort of legal issue. But gosh, you spent an extraordinary amount of time and got some good stuff, and you don't want to leave it. Think about whether you can leave it. And if it's material and important to your appeal, absolutely include it, and include it. I would submit in the text, not in a footnote. And then sometimes you just have to make those hard choices and say, I spent an enormous amount of time and I found good things, and maybe this will be relevant for another case, but I need to just remove it. It needs to fall on the editing room floor. Enormous block and indent quotes, another pet peeve that I have. You see much of this, I think, is kind of generational. If you look at regional reporters or, your reporters from your apex courts in the jurisdictions in which you practice, if you go back, I'm thinking probably in the 50s, you will see a ton of block and indent quotes. And I think some of it had to do with how opinions were processed. I'm old enough to know that on occasion, we'd pull things together using an old copier machine. Now you just do a block and indent from one screen to the next, and it's really quite easy other than formatting issues. But there was a time even before copiers where, editing things sometimes involved typing, literally typing a new draft from from to start all over, not just modifying an old one. And that, I think, became sort of ingrained in some legal writing, and it's painful. Almost always, you can truncate the quote to get right to the thing you care about. If there is a statute that has 250 words in it, almost always you care about 20 words or less in that statute. And if you can, almost always, and if you can paraphrase the rest, you're helping me as the reader get right through to where you need to go. And then the final sacred cow is adverbs. Be really careful about selection in adverbs. You can say things in a more colorful way, even an oral argument, that doing so in briefing may not really advance the ball very much. Now, there's a couple more questions. Let me just look real briefly. I notice the Supreme Court decisions are often very complex. Are they an exception to the long complex sentence rule because of their unique position? Well, I'm not sure. They are the highest court in the land for sure. But if you look carefully too, you'll also see some really varied and really good writing from that court. I am not a student of that court like I should be, undoubtedly, but if and just two examples, Chief Justice Roberts and Justice Kagan absolutely can turn a phrase in a way that that is punchy and quick and persuasive, but also consistent with all the legal norms and obligations that judicial officers have. And I toss them out as two examples. There are many others as well. Any good use for footnotes? I'm curious what kind of information you might consider as worthy to include in a footnote. Well, there are reasons to have things in footnotes. And let me share with you one that I include that some of my colleagues do not like. I include a footnote that will say, hey, unless we say otherwise, the rules and statutes and regulations that we quote are those currently in place, right? I do that as a kind of a placeholder. Another way would be for me to quote the entire statutes or, talk about when they've been modified. But if they haven't changed, I just want to tell a reader, not for today and not for tomorrow, but maybe 5 years from now, it's like, hey, we were looking at the rule as it existed at the time we decided the appeal. Another thing I will do for footnotes is note issues that have been raised that we aren't deciding. Because we don't need to decide. I want to acknowledge those, but those really I don't think are needed for textual support. We don't need to include those in the text. And then another example is if a litigant has many cases, or if I'll give you even another example, but to note that we're aware of those other cases. Another example that is a little bit more front of mind is a case where we're asked to decide something for the first instance, and there are a bunch of trial court decisions, maybe even from around the country, that conflict, but none of which are really dispositive or binding. I want to note those for the benefit of not only the parties, but also folks in the future who may look at what we did and kind of scratch their head and wonder why. So there definitely are reasons for them. It's just, use them with some selective caution. How about that? All right, so let's go to that next slide if we could. So here comes the pet peeves. And if you thought sacred cows were a little bit, Sam, idiosyncratic, my sacred cows are definitely idiosyncratic, or my pet peeves are definitely or maybe idiosyncratic. But the first one, and I know I was guilty of this in the practice of law, watch clutter, particularly in dates and facts. My view is that a fact should be almost essential, or it shouldn't be added unless you're using it for color, right? To describe, to kind of set the scene of what will follow. I see a ton of this with the statement of the case that will go on, and that's one of the early things that our rules require the parties to include. And if the statement of the case is 6 pages, you've probably lost me. I mean, that's a mistake. And I may care a lot about dates. I mean, a whole lot about dates. If the question is whether a case is timely filed, whether a limitations period has been blown. But if you're giving me 3 pages of dates and the question is whether defendant owed plaintiff a duty under the common law, why do I need to know anything about dates? I think you've wasted an opportunity when you do that. Irrelevant facts that don't add context, think about whether they need to be included. I think they probably can be stripped out without losing really anything. And if you file a brief that is shorter, you have gained something almost immediately. Pointed personal criticism of attorneys or parties. There's no room for that, frankly. And where we see it most on appeal, believe it or not, is from family court cases, where I think it is kind of a carryover from what trial judges in family court cases see a lot of the time. It's not persuasive. It's not really helping things. It may be in there because your audience is somebody other than the recipient of a letter, or the brief may be written for a client as opposed to an attorney. It's fine to tell the attorney, your client, I'm sorry, that the other side isn't treating them right. But show me that. Don't just sort of personally criticize the attorneys or the parties to try to make that point. Same thing with personal criticism of trial judges or concurrence, dissents, majority. That's written some for how us as judges need to treat everyone with respect and to try to keep our eye on what we're trying to do. The C. Johnson Supra, that's a relic again from the 50s. If you look maybe in the 60s, if you see older, pardon me, cases, sometimes you'll see that, and almost never is that the equivalent of an id cite. I think the longest I've ever done is I had to go back 6 pages before to see what Johnson was, to find even where I would find Johnson, because the downside of this is not only do I not know when Johnson was decided by what court, where I can find it, but also I don't know the page number for Johnson for this proposition. So you can cure that in our case by C. Johnson, 204 Arizona at 417 paragraph 4. That's just fine. It's just because you've told me something there and you've shown me where I can find things. But C. Johnson Supra, not very helpful to me. I'm going to look at another question here before we go to that next slide. In my experience, when a case raises an issue requiring statutory contractual interpretation of a vague or ambiguous term, how likely is it the court to take judicial notice of dictionary definitions? Under what circumstances should an advocate direct the court's attention to dictionaries, technical guides, or other non-authoritative materials? If you would bear with me, Timothy, I'm sorry, you have just introduced pet peeve 6. So let me turn to that. And if we can go to that next slide, Michelle, it's a great question. And it's something that I have almost an obsession about. Okay. So what I don't like is word X means Y, see some random dictionary. Okay. Why do I not like that? And it's always to deal with ambiguity in text, be it a contract, statute, constitution, rule, something like that. Well, for a lot of reasons. first of all, why is a specific dictionary selected? I would suggest that you need to hopefully get a dictionary that was in place about the time of when the text was created, right? So if you cite me a Bouvier's from 1849 for a statute that was enacted last year, I'm probably going to scratch my head and wonder why you're citing me a Bouvier's law dictionary. Secondly, I get the feeling you can almost tell in judicial decisions, and you can probably see some books over my shoulder, that the dictionaries that are cited are the ones that, yeah, right there, that are on the judge's shelf. And that's not a very scientific or good way to figure out what to use. The other thing, next thing is, do you want a technical dictionary, like a legal dictionary, a medical dictionary, or is it a general usage dictionary? And then the final thing, and then I'll give you some resources to, again, confirm that I have a quasi obsession about dictionaries and how they're used in the law, is dictionaries almost never have one single unitary definition for a term that applies in all contexts, right? Dictionaries have alternative definitions that rely on context. So word X means Y is almost never correct for a dictionary. Modifying that to say, well, depending on context, word X can mean Y is absolutely right. And that's helpful. But the dictionary, I think, is the starting place almost always for textual interpretation rather than the ending place. Now, again, the sources I'll reference to you on my obsession, if you type in Thumma in Westlaw, because it's not a very common name, you will see 3 law review articles that I've co-authored on the United States Supreme Court's use of the dictionary. One from Marquette, that's the most recent, another Greenbag article, and then the first article, which is like a book, was in Buffalo Law Review. And the Supreme Court started looking at the dictionary, first cited a dictionary in 1830 by citing, and I'll closely paraphrase here, the best French dictionary we have, right? That was the I have no idea what dictionary it was, but that's the one they cited. And the court in recent terms has used, okay, good. Thank you, Timothy, for that follow-up, has used dictionaries more and more and more frequently. And the last piece that we wrote, the Marquette piece, we tried to kind of set forth some approaches that courts and parties maybe should use when they're looking to dictionaries. So dictionary can be a helpful tool in helping resolve textual ambiguities, but in my view, it's the starting place, not the ending place. And where we almost always see it cited is as the ending place, which I think is probably not right. All right. Another pet peeve, humor. If you try to use humor in legal writing, be really, really good at it. Don't use it very often. And make sure, there's a good reason to use it. Almost without exception, I'd encourage you to avoid doing that for a whole bunch of reasons. You don't want to trivialize issues. You don't want to trivialize the other side. You don't want folks to think that your client is not taking something seriously. And I think humor, and I use it some, maybe with some success, maybe not, is best used in an interactive context, and writing is not particularly interactive. So it's best interpersonally. Next pet peeve, the surprise player or facts injected without introduction. I see these sometimes in drafts that I get, hopefully not drafts that I circulate, but you're on page 8 and you read about a witness and you're like, well, wait a minute. The witnesses were described on page 2, and I don't remember this person. And you go back and you look, and they're not mentioned on page 2. They just sort of fell from the sky. And make sure you introduce facts or witnesses, things like that, in a logical way, so you avoid the confusion that sometimes happens when you have a fact or a witness that just falls from the sky. Stretching dicta, the quote hopper, and then the Jack Brown rule. Be really cautious. I did this as an associate. You found language that seemed just great in a decision. You want to cite that decision. Jack Brown was my senior partner for a while, and he said, hey, look, until he passed away, he said, do not ever do that if the case goes the wrong direction. In other words, courts sometimes will say yes, but then conclude no. They'll have some dicta that will maybe kind of tossing a bone to the party that's going to lose. Don't use that if you can avoid it. Sometimes you can't avoid it, but work really hard to avoid that. Because let's say you have 3 cases that have great dicta, but they go the wrong direction, and that's the authority you have. In oral argument, the other side can say, Judge, I've read those cases, and they say that. And I like those cases because we win if you apply those cases. And if you want to do that, that's just fine by us. Don't give that power to the other side. And sort of a corollary of that is the selective court jurisdiction picker. We have on occasion, if it's a uniform act or a uniform commercial code, something like that, model penal code, fair enough. If there are other courts that show a real trend in going down that direction. The first case I sat on when I was on the appellate court, as a contrary example, was a tax case, and the opening brief or the answering brief, pardon me, on page 1 said, this is a simple case. It's an easy affirm, nothing to see here. On page 58 of that same brief, they started talking about the dissent from the Wisconsin Court of Appeals decision on whatever. It's long since lost the time for me. And I thought, all right, first of all, if you have a 58-page brief, it's probably not a simple case. And secondly, why should I care about a dissent in a Wisconsin Court of Appeals decision unless this is awfully complicated and unless Wisconsin law is a lot more similar to Arizona law than I think it is on that point. So, all right, so those sacred cows, pet peeves, that's what I have. Michelle, I'd be delighted if we have time to take any additional questions. The ones that folks have shared so far have been terrific, and I appreciate you sharing them with me.
If you have additional questions, please put them in the Q&A and we'll get to them. This has been really a great topic, and I think everyone's found it very useful.
It is my hope they learn from my mistakes, Michelle. And let me, I'll just, where we're looking maybe for a question or two, and I know the hour is getting late. Every piece of a brief that you file should be advocacy. And I don't mean over the top, conk the court on the head or the other side on the head with a hammer advocacy, but just little things that I see that are lost opportunities. Table of contents. The table of contents, you know, what's to follow in your brief should tell me what I'm going to see. And it is technically compliant for a table of contents in our jurisdiction to say the following things: table of authorities, statement of the case, statement of issues, arguments, conclusion. I have and have quoted a table of contents that did exactly that in a brief. Tell me what that table of contents told me about what the case was about, what the position was, what the issues were. Nothing. And if you can give me that in one-stop shopping, like on the second page of your brief, thank you. I'm really, really helpful, really appreciative of that. So a couple questions on books for legal writing. And let me share with you, and I've got a couple on my my shelf here. You know, they're both technical requirements, you know, and that's like the Strunk and White elements of style sort of thing, the Red Book, Chicago Manual of Style, and then qualitative things. And and there are many authors that you'll look to. Brian Garner, of course. There's a professor at Duke named Gopin who I've found quite good. But the person who I find most helpful in just me, right? And I don't shill for him, but to get suggestions in bite-sized pieces is a fellow named Ross Guberman. And he has both an ability to teach writing in like a, you know, hour-long bite-sized piece kind of way, but also he's written a couple books, one called Point Taken and another called Point Made. And this is actually Point Taken that I've got just right on my shelf. But there are many, and I don't pretend to to have, a definitive sort of, catalog of them, and it's got to work for you. It's got to work for you. What I shy away from are the books that sort of turn into like sentence diagramming, which I never understood in 6th grade anyhow, and I just don't find very helpful these days. Best way to proofread a brief if you're a solo practitioner. I will tell you, I'm the worst proofreader on earth. I am absolutely the worst proofreader on earth. So, but let me tell you what I have found that helped me. There's some software programs, spell check and usage, and Brief Catch is a software program that Ross Guberman has pulled together as well. But what I did when I had time was I would take what I thought was the finished product and I would close my door so people wouldn't think I was crazy, and I would read it aloud. And almost inevitably, I would find things that weren't there that should be, and I would find things that were there that shouldn't. That was something when I had time that really helped me be able to try to improve my proofreading. Now, Michelle, the request is, can I provide names of recommended legal writing books? And I'd be happy to. Can I provide that to you, Michelle, and have you circulate it around? Would that be all right?
That would be great. If you provide it, we'll go ahead and pair it with the recording that'll be posted on our YouTube channel.
I will write myself a note to do just that. And again, these are things that I have looked at that have helped me. They may help you, they may not. But I'm more than happy to share with you materials on my shelves that I found helpful. All right, let me just do a couple more if we're doing okay on timing, Michelle, because I'm really, how many typos and misspellings can you ignore in a party's brief before the attorney loses credibility? Not very many, and I wish the answer was different, because when I have typos and misspellings or misusage in what I do, I cringe. I hate it. And with my proofreading skills or lack of proofreading skills, it's unfortunate, but yeah, be as close to perfect as you can get. Would you agree that quality note taking is important to quality writing? If so, do you have any thoughts on what constitutes good note taking? When I was taking notes at depositions or at trials, I would try to take as close to notes or as close as I could to a transcript. So that's not a really very qualitative thing. Then I would sort out what I needed and what I didn't when I went back to write things, or to come back on redirect at trial or something like that. So some of that too had to do with whether I had dailies or not. And when I was on a trial bench, I did not have dailies, so I needed to keep pretty good track of what I kept. So one final one, Michelle, if you're okay with timing. I have seen many briefs or court filings where folks start off their briefs on the opposing side saying things similar to, so-and-so have wasted copious amounts of ink, yeah, and similar verbiage. Would this be a good example of what you referenced with avoiding pointed personal criticism? Yes. You're first of all, there are better ways of doing that. In your answering brief or the reply brief, you want to grab the court by the lapels and say, hey, no, listen to me. I've got the answer. What's going to follow will help you. So yeah, I agree. I would avoid that kind of approach. And then tips for explaining things that may be complicated. One of the best briefs I ever saw in my life was an intellectual property dispute. And it was on telephone switching systems when I was a clerk on the district court. And it spent 2 or 3 pages saying, hey, to understand this case, it's important to understand or to have a foundation for certain technological issues. And then it just described them, including, as I recall, a graphic, literally to see how things hook together. That was fabulous. That was fabulous. So you will have to explain complicated things to judicial officers and others, but it's just important we get it in the right bite-sized pieces. So Michelle, I think I'm a minute over. I'm sorry about that, but what a treat it's been to be a part of this. Thank you.
No, thank you, Judge. Thumma, we are so excited and happy that you spent your time with us this evening and really shared your expertise on legal writing. So thank you very much for your time and your willingness to come and share with our members. Thank you all for coming and joining us tonight. Please join us in March on the 14th. We have another webinar coming up on finding your passion by investing in yourself. So again, thank you all for coming. Thank you, Your Honor. We look forward to more webinars, and keep an eye out on the YouTube channel, the File for Delta YouTube channel, where we actually post the webinars probably in about a week or so. So thank you all, and I hope you have a great night. Thank you.